Premier Heating and Air has rebates on new units starting at $1,000. Indoor air quality products are free with the purchase of a new unit, and all types of financing are available for new units and for repairs. Premier Heating and Air, a locally owned and operated company. Log on to dublin.premierishere.com or call 478-300-2633. And for a limited time only, enjoy a one-time exclusive offer for new customers with our dispatch fee waived on your next repair. So call or log on today. Premier is here. Hello everyone, welcome in the studios today. Meg Greer Evans with Middle Georgia Estate Planning. Thank you for coming in today and talking to us. We want to talk about elder care. We want to talk about that time of life where so many of us aging Americans need to, if we haven't already, address some needs for later in life, to be prepared. What do you say about wills, Meg?
I have a lot to say about wills. So thank you so much for having me today. I always enjoy talking with you. So as we are focusing on aging Americans the next few months, it's sort of in my wheelhouse. When we're talking about estate planning, that's what we're thinking of first and foremost is a last will and testament. So when somebody says a will, that's mostly what they're thinking about after they pass away, what's going to happen to their stuff, their assets, and who's going to be in charge. And the will is the document that sets all that up. It's really important to have a will because if you want to dictate who is going to get your assets and who you trust to make sure that your wishes are followed, really the only way to do that is through having either a will that states all that out in writing that you've signed, that's been witnessed and notarized. Just talking to somebody, talking to your family, writing it down on a napkin, saying, oh, we'll write it down, we'll go to the bank later and get them to notarize it. That's not going to work. Even a draft of a will, even if you've maybe thought about it and written it down, but it's not actually signed, that's not going to work. So we definitely need to have that will in writing. And then the second part to that, which I think not a lot of people realize, is that just because you have a will doesn't mean you're avoiding probate. I think a lot of times clients will come to me and say, oh, well, since I have a will, we don't have to probate, right? And that's actually not true. A will is really the instructions to the probate judge for how to probate. So a will is instructions, and it doesn't mean that you're avoiding probate. So it's just important to know that as you're going into the process. But when you have a will, you do make the probate process for your family so much easier to be able to manage all of your assets so they go to who you want them to go to.
So let's talk about that for a moment now. You help someone with a will, and then that time comes, they pass. What's probate like? What does a family expect?
Absolutely. So probate is the process where we are bringing the will to the judge, in this case the probate judge of the county where you live. Whoever's the executor of the will is the one responsible for bringing the petition to probate the will. Something that you can technically file on your own, but I usually don't advise it just because there are a lot of technicalities. Of course, there are a lot of laws that are involved in that. And so, I'd always encourage you to seek an attorney who specializes in wills and probate to help you make sure all the paperwork is in order. So you're going to the judge, you're bringing that petition to probate. All of the heirs have to sign off on that. And so sometimes we run into situations where somebody may be an heir, like a child or a grandchild or whatever the case may be, even a more distant relative might be your heir, and they have to be served with the petition and a copy of the will, but they may not be the beneficiary of that will. And if somebody is an heir but not a beneficiary, you can imagine that they may not want to be all that cooperative in that process of the probate. And so I think that's what sometimes people worry a little bit about a probate of a will, is that when everything is sort of black and white, 1, 2, 3, straight down the line and easy, probate in Georgia is really not bad. It is a matter of bringing the paperwork to the court. It is a matter of the judge reviewing everything. All of the correct people have to sign and acknowledge, and then the estate is open when the judge issues what are called letters of testamentary, and that's actually an official document from the court that says the executor is now in charge, and then the executor can now handle business on behalf of the estate. But until you get those letters, the executor really can't do anything. And so if you have these situations that sometimes come up where an heir is contesting something because they feel it's unfair or they've been left out or something, then it can cause sort of a kink in the system, a delay in the system, and that's when people have bad stories about probate. And not always, there's lots of different possible things that can happen, but generally speaking, you know, like I said, probate is not a bad thing, but sometimes people do want to avoid it.
Yeah.
And the way, really the gold standard for how you avoid having to probate an estate is by having a trust. And a trust is, if I'm putting it in very simple terms, you are creating a document which functions a lot like a will because it's going to say what happens to your assets generally after you pass away. But you go ahead and during your lifetime, you fund that trust, you move assets into the trust during your lifetime, and you name a trustee to act, so very similar to an executor. When you can no longer act on behalf of that trust, then your named trustee carries out that trust. They do not have to go to probate. They don't have to file anything in court. They don't have to run ads in the paper. We don't have to serve people who are left out. So it can become much more efficient. It can become much less expensive. It takes generally a lot less time to handle it. And we're avoiding the public process of probate. We're also avoiding that potential contest of somebody who may feel like, hey, this is not fair. Well, we don't even have to notify them. If they're not a beneficiary of that trust, they don't even have to see it. They never even have to know that it existed at all. So some people really like the privacy of that.
Yes.
And sort of the efficiency that that can bring.
Yes, yes. So no public information is put out on a trust.
Yeah, I mean, there is a little bit that has to be recorded. So, you know, we record deeds when we're transferring assets into a trust, so somebody might see that. And then there's something called, in Georgia, a memorandum of trust, which gets recorded in the deed records that just says, hey, I have a trust. This is the trustee over the trust. And then that's pretty much it. So it's really shortened, and they're not seeing all the details of all the assets that are there or how things are being divided or distributed. So absolutely, it provides a lot more privacy.
Something to talk about there.
Yeah, definitely.
If you have very much at all, it would be worth talking about.
I think so. I think people are afraid of trusts, or maybe afraid is too strong of a word, but I think they can be confusing. Certainly as a baby lawyer, a decade plus back, when I first started practicing law, I was like, whoa, trusts sound really complicated. And I think sometimes they are, but that's why it's important to go to an attorney who specializes in it, because their job is to draft that document so it does what you want it to do, but then they can explain it to you in a way that you can understand so that you feel sure that your wishes are being achieved. But we can use trust for so many things. We can use trust during your lifetime if you just want to set up some protections and make it easier for your family later on down the road to administer everything. I often use trust for long-term care planning, which is sort of what we're here today to talk about. For elder law, which is something that I specialize in. A lot of times we're concerned about how are we going to pay for care, our long-term care, as we age. And it's also something that we worry about for disabled individuals, even if they aren't older, but maybe have a disability or maybe someone with a special needs child. It's something that we think about, a trust structure that's going to protect assets so that that individual can qualify for needs-based benefits like Social Security, SSI, or Medicaid, they can receive those benefits while also there still being a trust that protects assets for them to provide them a better quality of life. And so I often in my practice use trust for those individuals, and I think it works really well as a way of protecting assets, so that people can be taken care of, and then eventually whoever you ultimately want to receive those assets can still do that.
Yeah. We'll take a short break. We're going to be back, talk a little bit more about trust, talk about long-term care, and some other things that affect the aging Americans. Stay tuned. We'll be right back.
Hi, I'm Greg Carter with Shamrock Honda Kawasaki CF Moto. Come check out our full lineup of ATVs, side-by-sides, and motorcycles. We serve Dublin, Lawrence, and Central Georgia areas, and we'd love to serve you.
Back with you. Meg, we talk about trust, and there are things that you can move into a trust and administer from there, and there are things that you can't, right?
Absolutely.
So let's talk a little bit about that.
Sure. So generally speaking, a trust can own just about anything you can own. Real estate, interest in a business, an LLC, your stock in a corporation. It can own investments, something simple like a CD at a bank. It can also own investment accounts like brokerage accounts. But trusts generally don't own your 401k or your IRA because those are qualified individual retirement accounts. However, your trust could be a beneficiary of that account. So if you're thinking, okay, I want my IRA to eventually go to my 4 grandchildren, and they're all under 21 right now. Or maybe they're older than 21, but you think to yourself, maybe I don't want to just give them this money outright when they hit 21. I might want it to stay protected for a bit longer. So how might we achieve that? We would have a trust. It would set out parameters for beneficiaries, whether that's children or, in my example, grandchildren, to say, okay, when a grandchild reaches age 25, they're going to get half of the funds that came from this IRA. When they reach age 30, they're going to get the other half of the funds. And then we go to that IRA, we update the beneficiary so that upon the owner passing away, the trust becomes a beneficiary of those funds. The trustee can then divide them up into shares for each grandchild, and then each grandchild's trust functions for them. They can use that money for school, for health care expenses, for a down payment on a house or buying a vehicle.
Can you specify?
Yeah, you absolutely can specify. You can be as detailed as you want to be. Some people really want to be really prescriptive with it. Some people want to say, I leave it up to my trustee and their discretion. So we want to pick a trustee who we really trust. When we're talking about trusts, we're talking about trust. And it sounds sort of silly, but it's so true.
Could you have more than one?
Absolutely. You can have more than one trustee. Sometimes it gets complicated when we're trying to do like 3 or 4. Like if somebody says, well, I've got 4 kids and I want them all to be trusts. It's just a logistical thing that it's hard to get everybody on the phone or in person, certainly, to sign stuff. And there are things now that we can DocuSign. We send it through the computer. You may be familiar with that, or that may really bother you and you don't like that. But when it comes to trust, sometimes we're having to do stuff in person. So I'd say more than 2 sometimes is difficult, but it can be done. But yes, you can specify specific trustees for specific trusts. So this person is trustee for this grandchild, and this person is trustee for that grandchild. So we can get all into those details, or we can make it a lot more simplistic. But when we're talking about something like an IRA or a 401k, or even life insurance proceeds. If you've got a very large life insurance policy and you want that to be able to be spread out over a period of time, or you want that to go to, like I said, multiple grandchildren or multiple individuals, make that the beneficiary of those accounts or the beneficiary of that policy be the trust, and then we use the trust to kind of spread it out and make it go to all the people that you want it to.
Yeah, so a trust could work with a surviving spouse and then evolve into taking care of whomever.
Absolutely. There are a couple ways of doing that. One would be like if we're using a revocable or a living trust. Most people think of those as living trust. That means during your lifetime, you own that trust. Maybe you jointly own it with your spouse. The surviving spouse then becomes the sole owner of the trust. They can change the trust or not, depending on the terms of the trust. The trust could just be for their benefit. It could pay them a stream of income. We can use this also for long-term care planning if we're trying to limit the assets that maybe a spouse has because we want them to be able to qualify for Medicaid. We can use a trust to do that. So the trust can provide support for that spouse, but the spouse does not outright own those assets.
How long does that take effect, though? Because there's windows of time, correct?
Sure. So when we're thinking about long-term care and we're moving assets, there's generally a 5-year look-back period. So if anybody's ever talked to you about Medicaid, and that's really what we're talking about here, is paying for long-term care in a nursing home with Medicaid. And how do you qualify for that? Well, your assets have to be below certain thresholds. And so when we're talking about spouses, there's a higher threshold. Right now it's about $159,000 of stuff that you can own, and if you're over that, you don't qualify. If you're below it, you do. So when we're talking about this example of providing for maybe a surviving spouse, maybe we set up assets so that they're in a trust, so that the spouse doesn't own it, so that they're below that threshold. Because when we have two spouses who are living, that threshold's fairly high, $159,000. When one spouse has passed away, it dramatically drops to just $2,000. And so, well, what do we do about that? How do we protect that stuff? How do we just make sure we don't have to just spend it all? Well, put it in a trust. If we can proactively plan and move assets into a trust so that they are there for 5 years before we need to apply for Medicaid, everything we've moved is protected. After that 5 years, there's no look back. Those assets don't count against you for purposes of qualifying for Medicaid, but they're still there. They're held in a trust structure so that the people you trust are managing them for your benefit during your lifetime, and then after you pass away, they can be distributed.
And when you say Medicaid, that only applies to a nursing home, not retirement.
Right, so we're specifically talking about needing long-term care, needing a way to pay for long-term care in a nursing home, and that usually involves needing assistance with at least 2 activities of daily living and needing that nursing level care. So not assisted living, not what we think of as like a retirement community. And often there is a gap between maybe I'm living at home, I'm functioning totally independently, to maybe I need assisted living where I just need a little bit of help but still don't need nursing home level care. But then when your loved one crosses sort of that bridge to needing 24-hour-a-day care, then we're at a nursing home, and then it's 24 hours a day and it becomes much more expensive. Right now in our area in Middle Georgia, the average is about $8,500 a month. Statewide, the average is about $10,000 a month, with some places being more like $12,000 a month. Most people don't have that type of income. And so people come to my office daily to say, okay, how do I plan that if myself or my loved one needs to go into a nursing home, that we're not just having to spend down every single thing that we've worked for, that we've saved, that we've sacrificed because we wanted it to go to our kids or our grandkids, or even a charity or whoever or whatever you want it to go to. What do we do? How do we protect it well, the trust can be a really great way to do that.
Sure. Hey, we'll take another short break. We'll be back with Meg, so stay with us.
Hi, I'm Lily Rose Barton, and I have been coming to Bass for years. I had to come for knee replacement recovery. I had a bad back, I came for that. But this last stint was because I had SI joint fusion, and my right leg was very weak. Muscles were weak, but they have really built me up, and it has really helped. All of them, Erica, Whitney, Chuck, they all are just so good at encouraging you to do what you can, but don't overdo. Take it slow and easy. And taking it slow and easy has got me where I am today. From the front door to the back, they're all just very, very nice and helpful. And I appreciate all of them so much. I just can't express with words what they mean to me, but I do hope they know that I appreciate everything they've done for me through the years, not just since January when I started with this one. Chuck took me in. I brought the doctor's report from that. He put it in the computer. He studied what needed to be done. He instructed me how to do it, but he was right there every step of the way that first day. Not only do I do this, but when I get in the anti-gravity walking, at first, yes, I was scared because I hadn't been able to walk that much, but I have come a long ways. So it's just been such a blessing to have Bass to be able to come and do this therapy with them. And they're just so good to all their patients, but I feel like they've been especially good to me, and I do appreciate them. I would highly suggest that if your doctor were to suggest therapy for you, please tell them Bass in Dublin, Georgia is where you want to go. Any of them here will just be happy to work with you and get you back on your feet and able to do things that you were not able to do before coming to Bass therapy.
Hi, this is Meg Greer Evans with Middle Georgia Estate Planning, and just welcoming you to give us a call at the office if you have any questions about long-term care, whether that be a trust or a will. We could also help you with a power of attorney or health care directive, and with long-term care needs for special needs individuals. We're here to help. Give us a call at 478-272-2885 or visit our website at www.middlegaestate-planning.com.
Okay, we're back with Meg. Meg Greer Evans, Middle Georgia Estate Planning, and gosh, you say people come in every day. It's such a concern. Once you get 60, 70, you get 70, 80, and you're thinking, we have to make sure that what we work for is at least enough to get there on. And so that's a good place to start. We all want to leave something to our children. I think most of us, want to leave something to your children. It's biblical. It's of good merit, be able to leave something to your family. You'd like to do that. You don't want to spend it all just to care for yourself. So if you plan ahead and plan smartly with the right advice, and of course you can avoid that by and large, but just to have enough to get there on.
Yeah, definitely. So that you're bringing that up, it makes me think of another type of thing that I see in my office, which is maybe we have not planned ahead. Maybe we don't have 5 years. First of all, that's okay. I don't want anybody beating themselves up over that. Would've, could've, should've doesn't help us at all. We just need to say, okay, now we know better and we can do something about it now. Oftentimes people will come and say, well, we haven't transferred the house to our kids like maybe we wanted to do. Or we have, some money saved, but it's not going to be enough to get us through 5 years. Can we still protect some assets? And often the answer is yes. In sort of the estate planning field or elder law field, we sometimes call this crisis planning. I like to say immediate eligibility, like can I get immediately qualified for Medicaid? Maybe not immediately, but maybe sooner than we think. So there are lots of tactics for doing that. But one thing I want to caution against is people will just go to a lawyer and say, well, I want to deed my house to my kids, or I want to deed the farm to my kids. And the lawyer, if they're not specializing in Medicaid or long-term care, they may not know about the 5-year look back. They may not know that there's actually a penalty if you transfer assets and then you go to apply for Medicaid. On the application, there's a question: have you transferred any assets for less than fair market value within the last 60 months, 5 years? And if the answer to that question is yes, then your application is denied, and then they will impose a penalty. That penalty basically is what's the value of what you've transferred, divided by what they call transfer penalty divisor. Right now, that number's 10,025. And then whatever that comes to is the amount of months that you have to wait before you can apply for Medicaid again, which means you're paying out of pocket during that period of time. So that's not always a bad thing, because even if we say, well, we can't protect everything, we can't move everything into a trust, maybe we can protect some. And we are basically intentionally creating a penalty, because we know that if we move this house and we go ahead and apply for Medicaid and get denied, then we know this many months later, whatever that penalty ends up being, 8 months, 9 months, 10 months, maybe a little bit more, but we know that after that period of time, hey, we can qualify for Medicaid. So instead of 5 years, we're actually less than a year. Sometimes we're only 2 months.
So the penalty isn't financial, it's an amount of time.
Exactly, which does translate to finances, because it translates to paying out of pocket out of your finances, but it's not as though you're having to come up with a fine to have to pay. So we can strategically use that to our advantage to get qualified for Medicaid much sooner, but the strategic way is not to go to the lawyer, get a deed done, and then go to apply for Medicaid on your own. I want people to know that it's really important that it doesn't have to be me, but I am someone who's really studied this for a long time and worked on tactics and strategies to follow the Medicaid regulations, because that's extremely important. We certainly don't want to not tell the truth on a Medicaid application, because that could be Medicaid fraud, and that actually could be a crime. So we really want to be smart about it, and it's worth taking the time to go to talk to an attorney who specializes in it and can help you do it the right way. I like to tell people that I can almost get somebody qualified for Medicaid. It may not be today, it may not be 2 months from now, but if we approach it the right way and we're following the rules as Medicaid has laid them out in the manual, then we can almost certainly get you qualified.
Yeah, you know, it's this time of year. I choose a good accountant because I need help with my accounting. I want to pay my fair share of taxes, but I don't want to pay any more. I want to be smart about it. So I would choose an attorney who can help me in my financial matters and help me to plan ahead in life and to put assets where I would like them to be rather than leave it to chance.
Absolutely. And I think it's important to say, when we're talking about somebody qualifying for needs-based benefits like Medicaid, we all are going to pay our fair share. And when Medicaid is calculating that, it's based on your income. So there's always going to be a portion of your income that is going to pay for your care, and that's your fair share. And you know, your income, whether it is from retirement, whether it's from Social Security, whether it is a minimum distribution from an IRA or a retirement account, that's okay. We can say we're paying our share, we're paying our income for our care. But maybe our spouse at home doesn't have as much income as we do. Well, there are Medicaid regulations that allow that spouse to keep a certain percentage of the spouse who's in the nursing home, keep a certain percentage of their income so that they can still afford to live. Many people don't know that. So coming to somebody who specializes, who can say, okay, this is what we're going to need to pay, this is your share according to the regulations, but this is how much you can actually still keep. because often the people that are doing the applications at the nursing home, they may not know all of those regulations, and that's okay. I'm not saying that to put any blame on those individuals. They're just doing their job the best that they know how to do. I've studied the regulations. I look at them like almost daily. And so it's something that I've really worked to try to craft the best ways to help clients qualify, pay their fair share, but not pay or not have to sacrifice more than they have to.
Yeah. So for more than a decade, you've chosen to study elder care.
Yes, so I started off, many people know, I started off at my uncle's firm, Scott Thompson, who graciously gave me a job right out of law school, and I'm so grateful for that opportunity. And there I started with doing mostly real estate, but also just doing some simple wills. And then as time went by, believe it or not, I got really interested in estate planning and asset protection, which then led me to people who were saying, how do I protect my house so that the state doesn't come and take it? I want my kids to be able to have our family home. What do I do? And at first I didn't know. So I studied and was very fortunate to be given the opportunity under Mr. Johnny Warren when he retired to take over his practice in 2017, which is when I really dove straight into just solely doing estate planning and elder law. And since that period of time, I've really studied it and become really passionate, honestly, about helping people qualify for benefits that I feel they're entitled to. And like I said, I always will say, we're always going to pay our fair share. It's not that we don't want to pay for our medical care. It's just like we have insurance. We're paying our premiums, we're paying our copays. But then the part that insurance is supposed to cover, insurance ought to cover. And the part that Medicaid should cover, I think Medicaid should cover. And so that's what I'm helping families do, is just setting us up the right way, following the regulations as they're given out, but still being able to qualify for those benefits.
Okay. How would one get in touch with you to get an appointment?
Absolutely. So I will say that I'm booked out a little far, and that is just thanks to the Lord, I think. I'm booked out probably about a month. So if this is something that you have questions about, you're interested in, or you're confused about, you're like, what is a trust? How does it work? What is Medicaid? How would I qualify? I would just invite you to call the office. The phone number is 478-272-2885. And you can schedule an appointment, schedule it out maybe about a month or so that it gives you a little bit of time to start thinking about it. We'll send you a questionnaire. You'll fill out some information that we'll need. We'll come into the office and then we'll just talk. I just want to hear what your priorities are for your family, what you want to protect, what you value, and then we'll create a plan that's specific for you. I always want to caution people against going online. Some people are totally unfamiliar with what I'm about to say, but some people may know. You can go into something like ChatGPT or Claude, which is an artificial intelligence model, and you can go in and say, hey, I want a will. Hey, I want a trust. I want to qualify for Medicaid in Georgia. Well, I can tell you right now, I've actually tried to do it just to see what it would do. It gave me back Medicaid regulations that said that they did something. They were not Medicaid regulations. Totally made up numbers, not actually saying what the law says. I've asked it to generate a will for me. Same thing. It'll kind of give you something, but it's not what you want. And if you actually tried to use that as your will or as your trust, certainly if you were trying to use that so that you could qualify for Medicaid, that is going to create so many problems for your family down the line. Now, if you're saying to yourself, I don't want to think about AI, but I have Googled how to do this, well, it might pop you up a will or a trust from Washington State. Well, that's not going to help you either. So I welcome you to call the office. Just sit down and talk with me. If it's not something that you need, I'm not saying that everybody needs to have a trust, but it's something that we can talk through, figure out what's the best plan for you so that you feel a sense of peace of mind that you've protected what you've worked so hard for to achieve so that it can go to the people who you want it to go to.
It's great advice. Thank you so much.
Thank you.
Yeah, and thank you for joining us right here on TV 35.